Hello everyone, this is Tom Fox, and I would like to welcome you to a special 5-part episode on suspension and debarment. First, a word from our sponsor, Affiliated Monitors, Inc. Founded in 2004, Affiliated Monitors provides professional, independent integrity monitoring and ethics and compliance assessments nationally and internationally and across all industries. With its knowledge of effective compliance and ethics programs and cultures, Affiliated Monitors is respected for its work as the corporate monitor on matters ranging from multinational corporations to small and mid-sized companies and even individuals. Having served in over 700 monitorships, no one has more experience as an independent monitor than the team at Affiliated Monitors. For more information on how an independent monitor can help improve your company's ethics and compliance program, visit our sponsor, Affiliated Monitors, at www.affiliatedmonitors.com. In this 5-part series on the intricacies of suspension and disbarment, I'm joined by Rod Grandin. Rod is a managing director at Affiliated Monitors, and he's going to help us walk through what suspension and debarment is, but more importantly, why it needs to be studied, understood, and learned by the greater compliance community. We're going to take up 5 separate topics in this 5-part series. Number 1, what's the difference between criminal civil actions and suspension and debarment? 2, what's the actual difference between a suspension and a debarment? 3, what's the relationship to the FCPA and other matters to suspension and debarment? 4, what are factors considered as part of suspension and debarment present responsibility determination? And 5, what are some of the remedies and responses under suspension and debarment? I know you'll find this fascinating series very useful for you as the compliance practitioner. This special 5-part series on suspension and debarment is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox again, back for part 2 of my 5-part series that I am exploring suspension and debarment with Rob Grandin. Rob is a managing director at Affiliated Monitors. Today, we're going to take up the topic of what is suspension and debarment and go into it a little bit more into the weeds. Rod, I was wondering if you might be able to start off by really going over for us in some detail what's the difference between suspension and debarment.
Okay. Well, before I do that, I want to first point out again why this should be of interest to your listeners. In fiscal year 2016, the most recent year for which the federal government has published data, there were 718 suspensions. There were 1,855 proposed debarments and 1,676 debarments. In total, there were 4,249 actions that had to do with excluding parties from the federal marketplace. So, and again, someone could say, well, there are hundreds of thousands of contractors. True, but still, these are very significant numbers, and I just wanted to offer that as context. Now, when we look at suspension and debarment, suspension is designed to be temporary in nature. In fact, the regulations provide that a suspension can only be in place for up to 12 months. And to extend it beyond 12 months, you must have permission from the Attorney General's office. And then you can only extend it for an additional 6 months. The idea behind suspension is to essentially take steps protect the government's interest from a contractor that is believed to be unsuitable as a business partner until more of the facts can be assembled. Generally, the investigation is still underway, and there's a need to take protective steps before all the information has been fully gathered. But again, temporary in nature. A debarment, on the other hand, has a specific term. And it can be generally not to exceed 3 years. It can be more. It can be less depending on the specific facts in play. But the point is that debarment is for a specified period of time. There are evidentiary differences between suspension and debarment. The standard of evidence to support a suspension or when there is not an indictment is adequate evidence. And for practitioners, adequate evidence is a very low standard of evidence. Roughly, if you want to put it in the realm of percentages, somewhere north of 50%, somewhere above 50%. On the other hand, debarment, in the absence of a conviction or a civil judgment for specified offenses, the standard of proof is one of preponderance of the evidence, and that pushes you a little further north in above that 50%. I think again, if we're talking about percentages, I think comfortably you want to be well above that 50-50 proposition. So the procedural safeguards between suspension and debarment are not particularly all that different, at least under the procurement rule. And I must point out there are two sets of rules at present within the United States government. One is the procurement rule, which is captured in the Federal Acquisition Regulation, which is at 48 CFR. The other is at 2 CFR, Part 180, and it generally controls suspension and debarment actions for grants and other non-contract related matters. The procedures between the two rules differ to some extent, but for the most part, they are generally aligned, except as it relates to initiating actions for a proposed debarment. But in either case, suspension or debarment, proposed debarment, a suspension requires a notice. At the time that a party is entered into the excluded parties list on the System of Acquisition Management, or SAM.gov, a notice is issued to the contractor advising that the government has initiated the suspension and that the factual basis for the suspension and the rights and procedures available to the respondent as it relates to the suspension. As I said, the exclusion is effective immediately. In the proposed debarment realm, a debarment begins with a proposed debarment. Again, a party is put into this System of Acquisition Management on the exclusion list. A notice is sent out at the same time advising the party that they have been excluded from federal contracting. Under the procurement rule, that's an immediate exclusion. Under the non-procurement or the common rule, that is not an immediate exclusion unless the proposed debarment is also accompanied by a suspension. So those are sort of the general differences between suspension, debarment, and the procurement and non-procurement rule as it relates to the actions.
Rod, can you tell us who decides to go forward with a suspension and debarment action?
Yeah. So within each federal agency, there's at least one and sometimes more than one suspending and debarring official. Generally, these officials are senior government officials. In my case, with the Department of the Air Force, I was the Deputy General Counsel for Contractor Responsibility and a member of the Senior Executive Service. That is fairly typical across federal agencies. Again, the notion is these are fairly seasoned and experienced individuals that assume these positions. Where those individuals are located within the organization differs from agency to agency. As I indicated, within the Department of the Air Force, I was a part of the General Counsel's office. In the Army, that individual is a part of the uniformed service, even though it's a civilian that occupies. In the Navy, also part of the General Counsel's office. As you move to some of the civilian agencies, they can be placed in the acquisition community, or they can be placed in other parts of the organization. So sometimes identifying who is the suspending and debarring official for a given agency can be a bit challenging. And for those that are interested or have a need for that type of information, they can go to, it is, I believe, the ISDC, that is ISDC.gov website, which is the website for the interagency suspension and debarment community. And on that website, they do have posted what should be the current suspending and debarring officials for the various federal agencies.
So, Rod, unfortunately, we're near the end of our time, but I wanted to thank you for taking the time to visit with me. I've been visiting with Rob Grandin, Managing Director at Affiliated Monitors, and in today's segment, we took up a topic of taking a deep dive into what is suspension and debarment. I hope you'll join us again for our next episode where we consider why suspension and debarment is so important to the compliance community. So, Rod, thank you.
If you have any questions, you can email me at tfox@tfoxlaw.com. I hope you'll join us again for our next episode. This special 5-part series on suspension and debarment is a part of the Compliance Podcast Network.